the governor, being a well-known legal practitioner, it would have been strange if you had to defy the summons of the Senate. So to that extent, I think we don't need to get into too much debate because we are here. Now we need to agree, now that you are compelled to appear by summons, are you ready for us to prosecute the substantive agenda? Governor.
First of all, the record is correct as stated out in the summons, save for the fact that the invitation immediately prior to the summons was at a time when we had other invitations to appear before various Senate committees. And we did not choose not to come to this committee for any particular reason, save the fact that we had received the invitation from one of the committees before we received the one from this committee. So no disobedience was intended. Mr. Chairman, I will never want to defy orders or directions given by legitimate authority under the law or the Constitution. So I made sure that I answered this summons and appear as required. Secondly, on the second question, I know the committee is aware that there is a current stalemate between us as governors through the Council of Governors and the Senate about appearing before this committee. And I was seeking the indulgence of the committee that having produced the documents, I would not be comfortable moving any further step in defiance of the resolution of the Council of Governors, and urge that this committee, together with the Council of Governors, resolve that question. So I begged to decline to move beyond the appearance and decline to take the oath for further processes before this committee.
Honourable members, there is the issue of contempt, which has been purged by appearance, but then there is the other substantive work that we are supposed to do, which is the constitutional mandate granted under Article 229 of the Constitution. If the governor finds himself in a situation where he is not ready to proceed, then I think we have no option but to adjourn this meeting and deliberate and advise on the way forward. I think the easier thing would have been if the governor was ready to present his written responses, having taken the oath, we would have considered those written responses. But in a case where the governor is unwilling to proceed to take the oath and table the documents, then I believe as a committee we have taken a position on that. But what is important is that I think demonstrating that when the Senate summons you, it is not an invitation to a birthday that you can accept or deny. It is a constitutional obligation, and I hope that the other governors would also do so. We cannot build a society where the rule of law is not upheld. If everyone was to defy court orders, and if everyone was to defy directions and orders of Parliament, then it will be chaos. It will be anarchy. So unless there is any other comment, because if the entity is not ready to proceed and we have a very busy day, then the most likely recourse is to adjourn and take a position and communicate to the entity. Any other? I think in the absence of further views from the members, this meeting will adjourn. It goes on record that the contempt has been purged by the appearance of the governor, but the substantive issues have not been deliberated on. I think that's a record that we shall maintain. We therefore adjourn the meeting, and Governor, we shall communicate on the decision of the committee on the substantive